Good morning, everybody. Welcome to the sixth plenary session, where we will be debating the issue of conscientious objection in healthcare. We will specifically consider the following motion. This House believes that doctors in public hospitals have no moral justification for demanding conscientious objection accommodation as far as the delivery of professional services within their scope of practice to eligible patients who request those services is concerned. I am Teresa Rousseau from the Department of Immunology at the University of Pretoria, and I will be mediating the discussion. I'm really honored to have two leading ethicists joining us today. Professor Udo Schuklenk will be against accommodating state doctors who object to termination of pregnancy, and Professor Stuart Rennie will be arguing for such accommodation. Both are perfectly suited to consider the ethical issues of this debate. Udo is the Ontario Research Chair in Bioethics and Public Policy at Queen's University at Kensington. He is a long-serving joint editor-in-chief of Bioethics, the official journal of the International Association of Bioethics. He's an author, co-author, or co-editor of 8 books and some 150 contributions to peer-reviewed journals and anthologies. Stuart is an associate professor in social medicine at the University of North Carolina at Chapel Hill. He's a faculty associate at the UNC Bioethics Center and an extraordinary professor at Stellenbosch University. He has been involved with bioethics training and research programs in sub-Saharan Africa since 2004, primarily in South Africa, Kenya, the DRC, and Madagascar. The debate will have the following format. Udo will make his opening argument, and he will be followed by Stuart, after which each will then have a few minutes to respond to the other's arguments. We will then open it up to the audience for your questions, comments, and motions. Udo and Stuart, good luck, and we look forward to your word match, as we remember that only a wise person can solve a difficult problem.
Well, okay, so thank you very much for having me, and good morning, everybody. I'm looking forward to this session, and I'm certainly looking forward to our discussion after this presentation. So what I wanted to talk about is the issue of ethics of conscientious refusal accommodation in modern medicine, as you can see on this slide, perhaps. Small side comment, my email address is there, my Twitter account is there. On the last slide of this, there is a couple of suggestions for further readings. Have a look into that. Ask me to email it to you. If you can't access it for some reason, that won't be a problem. So as Teresa pointed out already, we were very careful to frame this issue in a way that is limited. So the scenario that I'm talking about here involves a decisionally capable, eligible patient who is requesting care from a healthcare provider. In brackets, it doesn't even have to be a doctor. It could be a nurse. It could be a pharmacist, for instance. The healthcare professional is acknowledging that, in fact, they do have a professional obligation to provide exactly this care. And yet the healthcare professional refuses to provide the service, not at all on ground of clinical judgment, for instance, but on grounds of their individual conscience. What I need to flag here is that the issue that we ought to be concerned about, to my mind at least, is not really conscientious objection, but the issue should be conscientious refusal. And the reason for this is that, of course, you could object to something on grounds of conscience, but then you do it anyway, because you know it is your job to do this, you have professional obligations, maybe you don't want to have penalties, whatever it might be. So the problem is not that somebody objects to something. The problem really is that then they also refuse to provide this service. The reason why I will probably switch forth and back between conscientious objection and conscientious refusal is to do with the fact that today conscientious objection is really the terminology that is being used in court cases, in policy discussions, and in bioethics too. So why are we having this controversy today in the first place? The first issue, I think, is that we have a wider range of medical services that some people, at least, find more controversial. And what I'm thinking about here is issues like reproductive health care, abortion, end-of-life issues like, say, terminal sedation, for instance, or euthanasia. In some countries also certainly care for gay and lesbian patients, transgender patients. This has gotten so bad that in the United States, in some states of that country, healthcare professionals have a right to refuse care even in life-threatening circumstances, and they will get away with it scotch-free. Other areas that have become also controversial, I forgot to mention this, is things like memory-enhancing drugs, for instance, say modafinil, for instance. If you get older and you try to focus better, people might object to that too, saying this is not a sensible thing to do, and I object to this on grounds of conscience. So really then, what happened here is that the culture wars, in a way, have finally landed in medicine. And when I say finally, of course, they've been there for quite some time. And I wanted to start off with a quote by Alta Charo. She said in an article in the New England Journal of Medicine a few years back, claiming an unfettered right to personal autonomy while holding monopolistic control, this is really important, monopolistic control over a public good, in this case, of course, the provision of healthcare, constitutes an abuse of the public trust, all the worse if it's not in fact a personal act of conscience, but rather an attempt at cultural conquest. Now, why is it that today we think conscientious objectors, many of us think in any case, and I think we're also mistaken there, but many of us really think that conscientious objectors are kind of honorable people. We should respect these. They are the real ethical people. And the reason for this is historical. And I, of course, can't go into my 20-minute presentation into the whole history of conscientious objection, but suffice it to say, it really rose to prominence in the context of pacifists, Quakers, and others refusing to join the army, and who were compelled to join the army and then suffered very severe consequences. They were murdered during the Nazi reign, for instance. They would be jailed in other countries if they refused to join the armed services during training that everyone had to go through. All this kind of stuff. And sort of as a fun fact that I've come across in the year 295, no kidding, some guy must have existed. And of course I wasn't there, so I can't really vouch for this, but his name supposedly was Maximilianus. And he refused to join the Roman army. And guess what happened to him? They killed him, of course. They murdered him. So the view then has been held, and you would find this in many international human rights documents, that these kinds of objectors ought to be protected. The problem is that what we are talking about today doesn't map at all on this situation. There's a fundamental difference. And the fundamental difference is that healthcare professionals volunteer to be healthcare professionals. Nobody forces them to do this. In fact, those of us who have worked in medical schools know that there are gazillions of students who can't even get into medical schools who want to become healthcare professionals. So it's far from the situation that anybody would have forced them. I want to quote to you something from a document by the World Medical Association. Many of you will know what that is. It's basically an umbrella organization of national medical associations, and I think it's probably really the only organization that has a claim to say we represent the views of the world's doctors. In brackets, even though most of the world's doctors might not even know that they exist, but leaving that aside. So they have produced a document that is today seen to be the modern version really of the Hippocratic Oath, which by and large is an unintelligible document, the Hippocratic Oath. So they updated this. It's called the Declaration of Geneva. And there they said the following: I solemnly pledge to dedicate my life to the service of humanity. These are the oaths typically that doctors would give during graduation ceremonies, right? I solemnly pledge to dedicate my life to the service of humanity. The health and well-being of my patients will be my first consideration. I will practice my profession with conscience and dignity. Here's the kicker. This is how this ended until 2017. And because so many healthcare professionals abused this clause, saying, yeah, I practice my profession with conscience, and so my conscience tells me. And so they had to add, believe it or not, and in accordance with good medical practice. This is what is supposed to drive this, not your conscience. You're supposed to be somebody who provides conscientiously good medical practice. It's not your conscience that drives your clinical judgment, though. So, what's conscience? Conscience really, and I'm quoting here somebody who I usually disagree with on most things, but I think he's right here, a former Catholic priest, Dan Macy. He said, conscience really is our conviction that we should act in accordance with our individual understanding of what morality demands of us, and on willfully and voluntarily acting in accordance with what we consider to be morally good and right. Of course, it acts both retrospectively. We feel crappy sometimes. We feel shame when we have done something that our conscience tells us we should not have done, as well as prospectively. In our case, doctors might refuse to provide abortion, for instance, or IVF for lesbian couples, for the sake of the argument. What I think is important here is that conscience has no relevant epistemic properties. There's no particular ethical insight. It's really a strong feeling that you have. You could be right, you could be wrong. And just to drive this point home, Nazis have a conscience, members of the Ku Klux Klan have a conscience. We all have consciences, and we could really be terribly wrong no matter what our conscience tells us. So we should not, to my mind, put too much weight on the idea there's something super ethical about somebody just because they say my conscience. Myself and quite a number of other colleagues in the field have come up with a thing called the incompatibility thesis. Unlike professional refusers, and I should explain to you what the difference is. A professional refuser is somebody, say you go to see a doctor and you have the flu and you say, can you please give me antibiotics, as people often do? And the doctor, as a professional refuser on clinical grounds, would say, well, of course I'm not giving you antibiotics because antibiotics don't work against flu viruses. It's a waste of time. Conscientious refusers, on the other hand, they decline to provide particular professional services based explicitly on rationales that are not professional judgments. That's why they are called conscientious objection. Their actions are only motivated by judgments that are conscience-based. So the point then is really that the only reason why they use this is because they know exactly what they ought to be doing. They know exactly what their professional obligations are. And yet, they decide not to do this. And this is then where this conscience stuff comes in. I just want to go quickly. By the way, Theresa, you at one point need to give me a heads up because for better or worse, I managed not to, my phone went off here. So I have no idea actually where I am in terms of time. Give me 5 minutes ahead of end a warning, please. So in terms of conscientious objector accommodation, I just want to give you a couple of arguments in favor, and I try to rebut them each time. The first is an argument that came up by Christopher Cowley, but also Mark Wickler. He was the first to come up with this in the academic literature. They basically said if you force somebody to act against one's conscience, this can result in a loss of integrity, and this in turn leads to strong feelings of guilt, remorse, and shame, as well as loss of self-respect. Worse, he says, to people dropping out of the profession, or if they know their integrity will not be protected, to not entering their profession in the first place. So my view here is really brutal, straightforward, and honest with you. Don't volunteer to join a profession where the delivery of some of their core services is threatening your integrity. Do something else. You could become, like me, a philosophy professor, or become a taxi driver, or a painter. You have no claim to be a healthcare professional or a gynecologist if you don't want to provide these services. Because the important bit is really that vulnerable patients here are the weaker part. Their access to services must always take priority over professionals' integrity issues. Bizarrely, the Council for Ethical and Judicial Affairs, which is kind of the ethics outfit of the American Medical Association, has said asking doctors to discard their personal conscience at the door to the clinic would have a detrimental impact on professional integrity. You won't be surprised to learn that there was no reference that would actually demonstrate that that is the case anywhere in the world. So really, it's an unsubstantiated claim. Because when you think about it, why could a doctor possibly contribute to the integrity of their profession when they prioritize their idiosyncratic private non-professional beliefs over their professional obligations? They refuse to provide professional services to eligible patients that these patients request, and here's another kicker, that they are the monopoly providers of. So here's another argument which of course, also very popular today, goes back to Jocelyn McClure and, oh goodness, I forgot the first name, but Dumont. They're both at the University of Montreal in Canada. And they said basically there's a problem with regard to people's equality of opportunity, because we do limit people's equality of opportunity by forcing them to choose between following their conscience or the profession they desire to join. So here's my view on this. First, patient access to care is of greater importance than protecting the equality of opportunity of people who are affected by, let's be clear, by the deliberate and voluntary adoption of these idiosyncratic personal beliefs that are not in fact intrinsic to the profession that they want to join. The other thing is limitations on our equality of opportunity rise in many contexts. And the example I always give is, I hope you can see this in the camera. My hands don't shake this badly, but I have a permanent tremor in my hands. Could I become a neurosurgeon? Hell no. Should I aim to become a dentist? No, I can't do this. So this is just a physiological issue that I have. I can't do this. Now, for people who choose that they don't want to do certain things that a neurosurgeon is supposed to do, maybe they should also do something else. And yes, of course, the equality opportunity is violated, but it's not clear that that is not a price worth paying. That's the point I'm trying to make here. And then there is an argument that I truly find bizarre, but in any case, I give it to you because it's also very popular these days. It's an argument from the loss of diversity. The argument here is that certain individuals might just not join the medical profession if their conscience claims were not readily accommodated. And my thing is, yeah, that's great. Because there's no evidence, of course, that patient care would suffer if the refusal to accommodate these people would lead to them not becoming medical professionals. That's great, because professionalism at its core is aiming at uniformly provided, reliable, high-quality services. That's what it's all about. The reason why we as societies have professions is that their members serve and maximize the public good. Conscientious objection accommodation achieves exactly the opposite. It subverts the reason for why we have professions in the first place as societies. So this is why I think there should be no accommodation, and I'm getting also to the end of this now. Here's one thing I haven't mentioned before, but I think it's very important. If we accommodate these people, we really undermine equal citizenship. How do we do this? Well, because we have people that we as society grant a monopoly to provide certain services to. And then these people tell us, the citizens that granted them this monopoly right in the first place, no, I don't feel like it today. No, my conscience, this is really terrible. And so as a result of this, we are no longer equal citizens, because their decision-making is completely idiosyncratic. It cannot be tested soundly, philosophically, ethically, whatever you want to call it. In the courts, it might be tested, but even there, not really. Because what we have is we have untestable conscience claims. And because of this, we have unpredictable consequences leading to what you could best describe as a healthcare delivery lottery. So these monopoly powers are liable to abuse, really. To my mind, conscientious objection accommodation, or worse, even refuser accommodation, is incompatible with the professional role that doctors voluntarily have strived, have agreed to. A different argument. 5 minutes? Oh, fantastic! Good. So I'm way ahead of myself. I spoke great. Now I should waste time. I won't. I promise. I just will be briefer. There is an argument that I think that I just wanted to draw to your attention, that you might want to consider looking up this book. God, it's so terrible now. I'm really losing my track. Oh, fantastic. So my friend Caroline McLeod at Western University here in Canada, she wrote a whole book, and I'll give you the reference on the last slide, where she argues that doctors really are patient fiduciaries. It's a brilliant argument. I hadn't thought of that myself. I think she's right. And this goes back both to the equal citizenship issue and to all the other points that I'm making here on this slide. Doctors cannot be patient fiduciaries if they prioritize their idiosyncratic private beliefs over the patient's best interests. It's just inconceivable. So this is why I think there should be no accommodation. I think there's 3 solutions to this problem. The first is straightforward, right? We should restrict really entry to medical school or specialty training to those willing to offer relevant services. Case in point, you don't want to provide abortion services, and the provision of abortion services is the responsibility in a particular society, say, of gynecologists, then you should not permit people to specialize in obstetrics and gynecology if they don't want to provide these services. They can go instead into, I don't know, dermatology, for crying out loud, or anything else, family medicine. The second thing one could do, frankly, is to demonopolize medical services. This has been discussed frequently in the context of euthanasia, for instance, saying, why don't we just train euthanasists? And I'm making up this term now, but basically we just train people to provide services that doctors object to. I just wanted to warn you that this is really problematic, because by virtue of the idiosyncratic nature of conscience, you never know what people will be ultimately objecting to. And because of that, you would probably end up in a situation that at one point you have no medical profession any longer. And if you really, and you should ask yourself whether you really want to do this, because they're so, at the moment, also well regulated. It gives us as patients a lot of safety and security when we go and see a doctor. Yeah, the other thing that can be done is to just remove the legal right to object to certain duties and deal with objections under labor law. This is, in fact, what is done in countries where they don't have conscientious objection accommodation at all, like Sweden, for instance. And there's a number of other European countries, and Scandinavian countries in particular, where that's not even possible. So I just wanted to flag these further readings. In the Journal of Medical Ethics, I had a paper. There's 2 open access papers in the British Medical Bulletin and one in bioethics. And they're not even paying me for this, but this really brilliant book with Oxford University Press, Conscience in Reproductive Healthcare, by Carolyn MacLeod. Thank you very much for your time.
Okay, I'm happy to be here, talking to you, wishing I was with you in person. And in response to Udo's presentation, I'm really going to walk through another perspective, which is a compromise position on conscientious objection. I actually seem to have failed to ask the question as it was asked for the debate, and asked another question of myself, and maybe the way that I formulated it tells you a little bit about where it might go. And so the question I asked to myself, is it ethically justified for medical professionals working at public institutions to refuse to provide care that is morally controversial but legal and part of standard medical care? And the short answer to that, is, or at least the answer that I'm exploring, is it depends. And that is a typical answer, I think, from a compromise position. So I'm going to go with a little bit of overlap with what Udo was saying, and then take it into another direction by looking at another way of seeing this debate. And first, why conscience is considered important, why it should be constrained as well, and some of the challenges, typical challenges to the compromise view, and some responses to those challenges. And driving towards a conclusion, also different from that of Udo, is that a compromise position on conscientious objection is morally complex. There's no getting around it, but it's not morally unsound. So I'm using basically the same idea of what conscience involves as Udo does. And why it's important is something that authors have debated for quite a while in terms of possible psychological harm if conscience is violated, if people are made to do what they find morally unthinkable, as the philosopher Harry Frankfurt put it. Religious-based repercussions in the eyes of the people who whose conscience is violated in terms of eternal life or salvation, the repercussions from their point of view, and the right to freedom of conscience generally is what makes conscience in principle important to people. The question being, of course, whether to what extent it should function within medicine. Though some people have said that it's important in medicine is all, and I won't go over what Udo was saying about diversity, including talented and compassionate individuals. There's a concern that if people were excluded who would possibly make conscientious objection claims, that you would be losing a lot of people who may be very talented and compassionate doctors, except that they were not willing to directly be involved in certain acts that they consider objectionable, as well as diversity in the profession. Oh, sorry, that's back. Let's go forward. When talking about a compromise view, that means that it's a constrained concept of conscience, that it's not just conscience without any limitations, but it's a concept of conscience that has constraints put on it because of the prospect of doing harm if the health services in question are not provided to the patients. I think it helps to ask, what does unconstrained conscientious objection look like? That would mean not providing the offending services, not referring to health professionals who are willing to provide them, not providing medical records, not providing patients with information about services, failure to notify patients or colleagues about refusal in advance, really completely disengaging from the provision of those services in order to preserve one's moral integrity, let's say. And what is the likely result? Patient harm and violation of patient autonomy. And I think, just as I think it would be good to have a rich empirical description of what conscience means to people who are conscientious objectors, I think it also is important to have a rich empirical description of what refusals can do to people. And MacLeod, in the book that Udo mentioned, gives a very good account of the possible harms of pharmacists conscientiously objecting to emergency contraception in terms of compounding social stigma about women's sexuality and jeopardizing the mental and physical health of patients via unwanted pregnancy. And more generally, the negative impacts on patient trust towards providers in medicine, which could be associated with those sort of refusals. Now, what is it like for conscience to be restrained as it would be in a compromised position? Well, what's the general aim of a compromised position? That is to constrain conscientious objection, not eliminate it, but constrain it such that to strike a reasonable balance between healthcare professional exercise of conscience on the one hand and the interests and rights of patients on the other. And immediately for some people, they'll wonder whether this is a worthwhile aim. They'll wonder whether this is a reasonable balance is even achievable, and will wonder about what sort of challenges this position faces. Some have created some guidelines for this kind of compromised position with constrained conscience. Wickler is the most prominent of them. These are the guidelines. So whenever feasible, healthcare professionals should provide advance notification to patients, surrogates, administrators, supervisors, etc. The accommodation shouldn't impede the patient's timely access to information, counseling, and referral. Shouldn't impede the patient's timely access to healthcare that's legal and consistent with accepted medical standards of care. It shouldn't impose excessive burdens on other healthcare professionals, supervisors, administrators, or organizations, and it should not enable discrimination. Those are the guidelines. These guidelines aren't, they're not defending the status quo. You could see them as providing a critical perspective on existing conscience clauses, such as the one that we have in North Carolina, which says no physician, nurse, or any other healthcare provider shall state an objection to abortion on moral, ethical, or religious grounds shall be required to perform or participate in medical procedures which result in an abortion. Now, if participate includes providing a referral, this law does not constrain conscience enough on a compromise position. And this is the same with many other conscience clauses worldwide, and some codes of medical associations as well, is that they fail to constrain conscience enough such that the possibility of harm to patients and violations of their autonomy is possible. So this is trying to strike a middle position. So just to take a look at each of these, well, most of these points, one after the other. This one about not impeding access. One of the most controversial aspects of a compromise position is whether a conscientious objector has reasons to refer. And the main objection being that why would a conscientious objector who thinks that a certain act is impermissible, morally unthinkable, why would that person refer someone to someone else to do that same thing? There's a few options for someone who takes a compromise position here. One is to try to mitigate, and a lot of the compromise positions have to do with pragmatic measures taken rather than necessarily philosophical arguments. Mitigate the prevalence of having to do referrals in the first place, making arrangements such that these referrals don't have to be done at all by people who have these objections. Sometimes that's not possible, and sometimes a referral is something that a conscientious objector couldn't avoid. And in that case, in a compromise view, they have to bite the bullet. And in certain contexts, they have normative reasons to be complicit by giving a referral. It is the least worst option in some cases. As far as impeding access, one might say, well, how could you not impede access in some settings, such as how could a conscientious objection not impede access in certain cases, like in rural healthcare? Well, there are some responses to this problem as well. Conscientious objectors should take responsibility not to choose settings where it's highly likely that they are going to, when they object, impede access. That's one point. Another is more on a systems level, that access to care in such settings should be increased. It should be increased anyway, by increasing the numbers of healthcare workers and the number of clinics as well. These are possible responses to these problems, rather than the more draconian response of just saying that conscientious objections should not be allowed ever, period. As far as not impeding, there is, of course, a problem when it comes to emergency care in cases of an urgent need of abortion, and in cases where also timely referral is not possible. And in the South African law, it doesn't allow a person who is, doesn't allow healthcare workers a way of getting out of assisting in cases where an emergency, a medical emergency for a patient is related to abortion. On a compromise view, this can be a case where some conscientious objections should be rejected. A compromise view of this type doesn't say that all, it's a compromise view, so not all conscientious objections should be accepted. And this is another case where conscientious objectors should bite the bullet. Another challenge is excessive burdens, and how does one, when if you're not providing the service, well, somebody else has to, and that can pose excessive burdens on other colleagues and on organizations. The usual compromise response to this is, well, it'll depend on context, how much of a burden those objections create. Again, the objector has a personal responsibility to avoid settings where excessive burden is likely. And burdens can be lessened by organizational changes, as well as hospitals accommodate for employee preferences in many other cases. You could say, well, this is all a lot of work. This is costly. It takes a lot of time, expensive resources, and so on. Aren't all these measures to accommodate for conscientious objection excessively burdensome themselves? I think a response by someone who takes a compromise point of view is well, there's little data on the impact of these measures. Excessive, whether these excessive or not, are in the eyes of the beholder, and are also context sensitive. And this view, at least the compromise view, one could say, is at least if we can get away from excessive burdens on others, it has the advantage of preserving something which has some value from this point of view, and is preserving a constrained form of conscientious objection. As far as discrimination goes, what stops conscientious objection turning into discrimination against minority groups, for instance? I think the accommodation view or the compromise view would say, well, anti-discrimination laws would do that, since conscientious objections are about types of services. They're not supposed to be about classes of patients. But this does raise the question that, or it does raise the issue that laws, policy, and conscience clauses should explicitly state the unacceptability of discrimination based on conscience, because oftentimes they don't. Another issue is what stops a medical professional from refusing to, and Udo touched on this a bit, refusing to provide a health service on any old basis, including ones not even related to conscience. I think a compromise view would probably first start off by saying, where's the evidence of this? Is this something that people are doing? I don't know if there's any data about this, and it's not clear what the person's motivation would be as a health professional to be doing this sort of thing. But it is reasonable to ask objectors to explain themselves in these cases, given what's at stake in conscientious objection. There, of course, have been proposals about sincerity tests where you're supposed to ask about core moral beliefs, and their answers should be consistent with empirical information and should be non-discriminatory and so on. This is what I think one of the sore or difficult spots or work in progress spots of a compromise view, in fact. A further issue is about aren't, and as it's often put, a conscientious objector putting themselves first, their own interests first before the interests of the patient, which of course sounds terrible. Or isn't the doctor, when conscientiously objecting, in fact just intentionally giving suboptimal care to patients, which also sounds terrible? I think the response by a compromise view would be, well, it can't be the case that healthcare professionals have to do everything to promote patient care. That can't be exactly what putting patients first is, because they have healthcare professionals have their own legitimate interests, and they're not supposed to make unbelievable sacrifices for their patients or anything. They can take vacations, and they're not supposed to be expected to pay out of pocket for patients unable to pay, et cetera, et cetera. And when it comes to putting patients first, in the guidelines for a compromised position, you can see that the compromised position, the constraints are constraints which have to do with trying to preserve patient access to care. So that value is still embodied in it. You could say, and it often is said, that failing to provide abortion and other services by conscientious objectors violates professional obligations. Well, only some providers have a possible obligation to these particular services, of course, so drilling down on them. One question that has been asked in the literature is, how are relevant providers violating their professional obligations if they're working in jurisdictions where society, medical authorities, and the law support conscience clauses? The question then is, so what determines what professional, professional obligations are? And perhaps what Udo was talking about in terms of fiduciary obligations, one could create a theory such that this particular challenge to the compromise view could be strengthened. I haven't seen that one yet, but that's a possible challenge that a compromise view has to come up with an adequate response to. So my conclusion, tentative conclusion, is the main concern about conscientious objection is about impact on patient welfare and rights. A compromised position tries to preserve a conditional moral space for conscientious objection, which is constrained by concerns about patient healthcare access. This position could appeal to those who see the value in conscience, care about the rights welfare of patients regarding morally controversial services, and don't want to choose between them. Like I said, this is a position which is undoubtedly morally complex, but it's not morally unsound. Thank you.
Thank you, Stuart, and thanks, Udo, for putting your arguments forward. So for me, it seems to come down to having or not having a conscience if you are in the medical profession. So you've heard Udo arguing that there is no place for conscientious objection, and you've heard Stuart, you cannot discard conscientious objection without actually doing harm. So Udo, you heard Stuart say that your view is draconian. So how do you respond to Stuart?
There's several answers to that. The most obvious is to say, well, it may be draconian, I might still be right. Maybe we are just foolish about how we approach this whole issue, right? But then I also don't think it's draconian, because the truth is, we have fully functioning liberal democracies in some Scandinavian countries where conscientious objection just doesn't happen. It's not in the law, there is no policy, there's no tradition of that kind. These healthcare systems function perfectly well. Patients are not suffering as a result of this. They get professional services, and that's the end of that. Now, you could say they're all super draconian, but I think it's stretching it, to be honest. It's just, as I said, we make this mistake that we think conscientious objection is an honorable activity, when I think in the professional context, it just isn't, that we are concerned about. Let me perhaps take the next few minutes to respond to at least some of Stuart's arguments. In fact, we agree on lots of things. It's not that we are in complete disagreement, but then it's easy in a way, because he actually settled on a compromise position as opposed to saying, no, conscientious objection is the best thing ever and we have to protect it at all costs. So that's much more difficult to attack for me, obviously, or to respond to. In any case, the first thing to note is perhaps that these compromise positions and policies don't work anywhere. Fun fact. And yes, we have a lot of empirical evidence. It's not that we don't know that. People who work in reproductive health and look at the issue of abortion have undertaken large-scale surveys on access to abortion services. And we know that these effective referrals, and whatever it's being called, have only one function: to subvert people's right to access these kinds of services. And they're very successful at that, actually. So that's the first thing. With regard to euthanasia, I can give an example. In Canada, we have effective referral here. Effective referral here means actually that dying patients are being literally carted around between hospitals, sometimes hundreds of kilometers, because in some hospital they can't get these services, and then they have to be carted to some other hospital. And Canada is a big country, so it's absolutely torturous what people are being subjected to there, and this goes under the guise of effective referral. Now, Stuart would say, this is not what I had in mind, but the question is, what actually did he have in mind? I don't mean this in a really nasty way, but what exactly? Because the problem here is that you are going on about proportionality, but proportionality with regard to something that you can't actually grasp, with this conscience. As I said, no epistemic value. People have all sorts of idiosyncratic beliefs, right? And they might even hold them strongly. So why should this be of greater significance than these kinds of dying patients, for instance, in Canada, accessing their rights? You actually flagged all the reasons for why we should not have the compromise position. It increases the workload of colleagues willing to provide these services. And in South Africa, you know this perfectly well. I mean, I've worked here anyway. I've seen it. The few doctors willing to provide abortion services in Johannesburg, they're overwhelmed because of their holier-than-thou doctors refusing to do their work. That's a reality, all right? And patients suffer as a result of that. Of course they do. It delays access to care, I mentioned this, but also important, it really reduces the efficiency of the healthcare system, because you are busily working around these people as opposed to them doing their work. Where I need to be clear is, you mentioned South Africa, and then you come back to this on a slide later, where you say, yeah, but in law, conscience clauses are enshrined, they are protected. And of course they are, but the whole point of my argument is they shouldn't be there. They shouldn't be protected. While they are there, of course, within any democracy, people are entitled to use their rights. And they're abusing them left, right, and center. And this is why changes need to occur. This is, of course, implied in the argument that my side of the argument, at least, is making. You mentioned a sincerity test, and I didn't have time to do this in this presentation. There's two types of ways how people typically approach this compromise position. They say either the objection is reasonable, and then the question is really, what is reasonable if all you're saying is on idiosyncratic private beliefs, you don't want to do what is the expected gold standard of care. That's the reality. So what does it even mean for something to be reasonable? Then there is nothing there really, right? But then the other thing is, and to be fair, this is not the argument you made, Stuart. You came up instead with the sincerity test. And the sincerity test is, of course, something that's never going to happen, right? Because how do you test possibly the sincerity of these idiosyncratic beliefs? You will have these culture warriors basically providing training to these people to make sure they give the right answers. Don't delude yourself. And I'm just talking about this now from a policy perspective, from a very pragmatic perspective, right? How is this actually supposed to happen? The reality is you cannot test whether somebody is sincere. You got to face that. And then the other problem is, and I mentioned this and I'll leave it at that, there are sincere Nazis, big deal. Now, conveniently, you exclude all the people that you don't like, but frankly, you have no reason to do that. Why would one weird idiosyncratic personal belief be any more valuable than some other weird idiosyncratic personal belief? Why should so these are all arbitrary lines that you're drawing. You say discrimination must not happen. The reality is, this is the whole purpose of this. It discriminates against women. It discriminates against gay and lesbian patients. If you exclude all of this, then there's not much left for these conscientious objectors, because this is what excites them. You got to be realistic about the politics of this, especially in the United States. You should be well aware of that. And I'll leave it at that. So thank you very much.
Well, Stuart, let's hear from you. You heard Udo saying that your approach is just not going to work. How do you respond?
My immediate response to that is that where he's going in terms of sort of eliminating conscientious objection from medicine, I don't think that's going to work. I don't think any more than Sweden is, United States is going to become Sweden or something like that. I don't think that the chances of that seem very slim to me. Rather than, I agree with a lot of, we're doing a bad debate clearly because we're agreeing with each other a lot. But I do agree with, there is a lot of abuse that's taking place. I do believe that there's a lot of conscience clauses which are absolutely more protective of healthcare professionals than they are of patients, for sure. The question is, okay, change is needed. That you can cite data, you can look at lousy clauses, but the question is what kind of changes are needed? Is it reform, or is it just eliminating conscientious objection altogether? Now, if you ask me to be realistic, I would say, well, one should at least start with a better compromise position than that we have. Even if you decided, well, we're on the road, if the march of reason or whatever, we're on the road to eventually eliminating it. A compromise position would already be an improvement, perhaps, than what we've already got, because what we have, is being abused. The question is how much of what you're complaining about and what I'm complaining about has to do with the failures of a compromise position, or the failures of something which isn't a compromise position. In the United States, for sure, I wouldn't describe the sort of guidelines that I, communicated are being violated left, right, and center. It's not those can so easily be brought in as a criticism of a compromise position, rather than a criticism of, something which is more like what's called in the literature conscience absolutism. There's a lot of that going on. So the question is whether there's still a viable position, which is a compromise position, rather than, I call it draconian, but that's just rhetoric, a more extreme from a certain perspective position. I don't know if I was taking notes, but well, I think probably some people would take would be, let's say, unhappy with calling conscience beliefs something that had no epistemic properties. We'd have to go into that a little bit about epistemology maybe, and it can't be, they have no epistemic properties because they could be wrong on that criteria. Nothing has an epistemic property, but I think that a lot of these beliefs that people have, I don't think it's a correct characterization, though I think, more research is needed, that the people's beliefs who are conscientious objectors aren't like kooky, crazy, idiosyncratic. I mean, you can say that if you like, but idiosyncratic, magic healing powers of crystals sort of beliefs that they have. A lot of these beliefs, they're patterns that, they come from moral traditions or religious traditions. They're not simply personal. They're very much intersubjectively shared. They're very much things that are rooted long in cultural history. I'm not going to say that cultural history makes beliefs correct, or, of course, but I think that part of the discussion that one often has in these debates has a tendency pretty much to discredit conscience. That's like one of the main argumentative moves, is to just discredit conscience to further a certain argument. And I guess, it's no surprise that this is a debate. It's kind of a proxy war, cultural proxy war. And a lot of implicit ideological commitments drive the arguments. I could, when I was going through the compromise view, I could feel it. A lot of implicit ideological commitments about abortion, about medical assistance in dying, and so on, drive a lot of the arguments that you see in the literature without being explicitly said.
Yeah, then
well,
I think
thank you so much to both of you. I think we actually need a lot more time to delve into those very interesting questions that both of you have raised. And it's a pity we can't be together in one room where we can, just take the debate further. But at this point, we're going to open it up to the audience, and we will hear what comments and questions they have for the two of you.